Hello, friends, welcome. Friends, today I am going to talk about a very, very important development. What is that? This is basically the Bombay High Court decision, judgment, which they deliver on 20th September 2024, means yesterday. And this judgment is pretty significant. So, what I did, friends, is I actually went in the morning through this judgment, line by line. This is a 100-page judgment. It took me a lot of time to go through this judgment. And in this video, I will explain to you the implication of this judgment, why this judgment got delivered, and what are the implications for a common man, right, of this judgment. This is very, very significant, and this is going to strengthen our democracy and make individual voice get heard without getting stifled by the government in an arbitrary manner. Now, before I take you through the details, in order to make this discussion more structured, what I have done is I have penned down everything in an article, because that will make the discussion more structured. And for those viewers who want to get a summary of this discussion, can go and read my article which I wrote in Substack very recently. Let me just show you my article. So this is my article. So I just wrote this article 2-3 hours back. Now what this article does is it kind of captures the summary in the opening paragraph, right? So the summary is as follows. Just to give you a brief summary, what happened was that when this amendment was made, the amendment which I showed you just now, which is clause 1B4 of the Information Technology Intermediary Guidelines Digital Media Ethic Rules of 2021, which was amended on 6th April 2023, and that clause was inserted, this clause which I was talking about, clause 3.1b. That clause had a provision of the intermediary getting out of the provision of safe harbor in case they do not fulfill the direction of fact-checking unit, which had the power of branding an information as false, misleading and fake. So that is what is written there. So if the fact checking unit, which the government is going to notify, and the government itself is going to decide whether that information is false, fake or misleading, and if they notify that, and if they inform the intermediary that, look, this is what the information I want you to take out from this, and if they don't, and the intermediary does not, then what happens is, then it is no longer liable to having a safe harbor. Safe harbor means that intermediary is immune to any kind of post done by the users of the intermediary. Means users, if they do some kind of post, intermediary should not be responsible unless certain provisions are followed or guidelines are met. And one of the guidelines which is incorporated was FCU, fact checking unit, which would brand an information as false, fake or misleading. Now, against this, a petition was filed in the Bombay High Court, and the Bombay High Court came out with a judgment in February 6, 2024. And that was a split verdict. Two judges gave two different verdicts. And that is why what happened was that the matter actually went to Supreme Court. The reason it went to Supreme Court is that before this when the judgment was made, when the split verdict was made, then naturally the tie breaking was required, and there was one other judge which was entrusted with the task of the Bombay High Court to break the tie. When the tie breaking process was on, when the matter was heard by the third judge, who actually has given this order, which is 30th September 2024, the current order, when it was heard on 20th September, I think on 11th March 2024, it was heard, the matter was heard, then no interim relief was granted because the fact checking unit was not notified. And there was some kind of assurance given by the government that they will not notify the fact checking unit till this process is over. But since the interim relief was not granted because of the fact that the fact checking unit was not notified, government actually notified the fact checking unit on 20th March 2024. And that's why the matter went to Supreme Court, and the Supreme Court quashed that notification and stayed that notification and said that till the time this order comes, September 30th, 2024, which is the order which came, finally the judgment basically concluded and the tie was broken. that is that fact checking unit is going to be stayed, and that is what was the status quo. Now that's why this order is so important, this judgment is so important, because it now has put a finality to the Supreme Court judgment and made the fact checking unit of the government completely ultra vires as per the provisions of the Constitution. Now what happened was, in the judgment of the 6th February 2024, there were two different buckets of decisions which were taken. One set of decision, the two judges agreed, or one of them remained silent, and another set of decision or the provisions where the two judges actually disagreed. Now the tiebreaker judge actually went into each and every aspect of law, and only those aspects where there were disagreement he went and educated, and rest of them he didn't really educate it because there was no need, because that is how the education is supposed to be done. So the points where there were no disagreement, where the judges agreed, was classification and discrimination. And this is very, very important to understand that what does classification and discrimination means. Article 14 of our Constitution basically is called right to equality, right? Those who have some understanding of Constitution or can go and look up in the internet, everything is available. So this is called Article 14. Now Article 14 basically gives a citizen an equality before law, means right not to be discriminated unless it is justified and can be properly explained why you are getting discriminated. And therefore the central government did not have had the power to constitute itself as a unique class deserving professional treatment unless it justified why it is requiring to do so, because central government itself is acting like a class. And because it is acting like a class without any justification, therefore there is a clear violation of Article 14. I think you probably understood, and there is no point in, you can read this article and you will understand what is being talked about. So this particular fact was agreed, and there was no disagreement on this particular fact as far as the second judge is concerned, right? So the next point where there was agreement was the violation of principle of natural justice. Right. So what does natural justice basically mean? Natural justice means that there has to be a procedure for fairness, and there has to be a procedure for reasoning as to why an FCU order is supposed to fulfill a certain task, and why it is branding a certain class of information as fake, misleading, and false. So that did not resonate with the principle of natural justice, and therefore the principle. So if you look at the theme here, it will say violation of procedural fairness. There was no fairness combined with the absence of reasoning, a reasoned order from the FCU. So these are the two things where there was agreement, or there was silence by one of the judges. Now this is now getting very important. Points of disagreement among divisional judge and rationale behind tie breaking. Now if you look at, there is an article called Article 19(1), and there is the provision called 19(1)(a), and then in the same article there is a clause 19(2) of the Indian Constitution. Now, when you are reading this article, you can actually focus on the key education themes which I mentioned before each and every section of this article. You can understand that. Now, what does it basically mean? Article 19(a), if you go and read the article, you will find that this article basically says that there is a right to freedom of speech and expression. Now, what the judge said, one of the judge said that it basically said, yes, there is a broad right of freedom of speech and expression, but it does not include a right to truth, which basically means that the fact checking unit is doing what? It is trying to extract truth. Now, right to know or right to have freedom of speech does not mean that there has to be a right to truth. This is very, very important. That, there is no point in emphasizing on truth. This is not what the Article 19(1) says. As long as that truth or falsehood in any way does not become detrimental to the provision of Article 19(2), which is called reasonable restrictions. So you have to fall within the 8 provisions. There are 8 provisions in, if you go and read, there are 8 provisions in Article 19(2), under which if you fall, and if your information or whatever you are expressing falls under those 19(2)(8) provisions, then the safe harbor provision in the intermediary guidelines is lost. Okay. If you continue to allow that information to get disseminated or remain in that particular intermediary website, you will no longer have safe harbor and you will be liable to penalty. But as long as it does not fall within the bracket of an Article 19(2), which is reasonable restriction, then you are no longer allowed to go overboard and go beyond those 8 provisions which are there in this Article 19(2). And that is where the problem was. That is exactly the problem was when you come out with a fact-checking unit and you do not remain within the Article 92. Because if the fact-checking unit clause, if you see that, it basically says that if there is something which is inaccurate in the business of central government, limited to the central government, it can be anything. It may not fall within the 8 provisions in the Article 19(2), then it can be taken out and be considered as ultra-virus. It can be taken out from the intermediary, and if they don't take out, and it becomes a violation of the intermediary guidelines, and they do not get the safe harbor provision, right? So that's where the issue was. And the other judge basically said that no, it is not the case. He pointed out that Section 79 of the IT Act underscored that the loss of safe harbor could only occur if the content explicitly violates. So she is also saying the same thing, violates. Thereby the ruling automatically removes the safe harbor protection for reasons outside the specific content. So I do not know what was the specific reason for disagreement here, but there is some nuances of the law in which the disagreement happened. But the tie-breaker judge mentioned that the judge noted that the rules improperly attempts to control the transmission of information, which was defined by the IT Act Section 2115, based on the content which does not pertain to the 8 subjects listed under Article 19(2), which I was basically mentioning. Then comes the right to profession, which is Article 19(1)(g), and it is read with Article 19(6). So if you go and read that, you will understand what is being talked about. And key theme here, the point about education was no FCU for print media and only for digital media, means selective provision. So if you look at the provision of the intermediate rules, what it does is it has a fact-checking unit only for digital media and not for print media. So that is where the problem was, and that problem was got caught. And what the one of the judges said, that he argued that the discrepancy leads to a kind of censorship that only applies to digital content, resulting in a direct infringement of Article 1(g) of the Constitution, right, which protects freedom of practice of any profession to carry out any occupation, trade, or businesses, right? And Dr. Gokhale, she basically had some different view. I don't want to emphasize on that because that will take too much time for this video. So the tiebreaker judge agreed to this point, and he pointed out the lack of sound basis differentiating between digital and print media in terms of factual scrutiny applied to information related to only central government. This differentiation unjustified and infringes the right to get protected under the Article 1(g), which is basically freedom to practice any kind of profession. Now, this is the violation of Article 14 of the Constitution. What is the education theme here? Equality before law breaks down as in a fact-checking unit, government itself is the final arbiter on this own cause. Means it is the judge, the arbiter, as well as everything. It's all encompassing the same. So it decides and does everything on its own. So that's why the Article 14, which is basically talks about equality before law, it breaks down, right? Now, if you look at what the Judge Patel J, learned Judge Patel J basically said, he pointed out, and this is very important, that this direct control over determining the authenticity of information related to government business create an inherent bias, violating Article 14, which mandates equality before law. And the tiebreaker judge also agreed, and he says that in this arrangement he argued the lack of necessary impartiality, particularly when similar information is being treated differently across digital and print media, leads to an inconsistent application of rules. Right? So that was this particular aspect of it. Then there is a divergence of application of knowing knowing and intentionally. And this is little technical. Let me explain to you what it basically means. It will get too confusing, and therefore I have to go straight to this particular provision of the no, not this. Let me just go straight to this one. So if you look at this, which is the article of the Intermediary Guidelines of 2001, the rule of 2001, which was modified. Now read this properly. This is very, very important. So what I will do, I will make it single page continuous, then only it will make sense. So let me just go and see and become big. So here what it says is, if you read this, it says that deceives or misleads the addressee about the origin of the message, or knowingly and intentionally communicates any information or information which is patently false and untrue or misleading in nature. Okay, so this ends here, and then there is a provision of or here. Look at this. See, this or breaks this particular portion of information of the clause into two different. So this is one, and this has become one, right? This is the other, right? So let me explain what it is basically saying. Or in respect to business of central government, identified as fake, false, or misleading by such fact-checking unit of the central government. So basically, what it is saying is that this word knowingly and intentionally is attributed to only those information which is other than what will be determined by fake, false and misleading by the fact-checking unit of the central government. So if you are, so in other words, what it means is that if you are publishing certain information, then this word knowingly and intentionally, this is not applicable to the business of central government. So it is only applicable to information which is other than the business of central government, which will be falling under the realm of fact-checking unit. Now, if I go now with this explanation and we start reading this, which will become extremely clear now. So what it is basically saying, let's read the theme. It says, separate standard for government content where the intermediary compliance with the FCU determination rather than user intent becomes crucial. So let's read what the judge is saying. Judge basically is saying that the knowingly intentionally communicates in clause 3.1b5, which we just read, specifically apply to the clause addressing information or content that is false, misleading, and does not extend to 2023 amendment involving the central government business which is educated by the fact-checking unit without requiring the user knowledge or intent. Means there is no need for user. You may be unknowingly, sending some information, something like that, which is not intentional. Still, that information can be branded as misleading, false, etc. by the fact-checking unit, because the provisions of this particular clause 3.1b is not uniformly applicable across all kinds of information. And that is what the tiebreaker judge says, that it says that the tiebreaker judge sided with Mr. Patel's noting distinct treatment of content related to non-central government versus central government business under the rule. He recognized that the new clause has created a separate standard for government-related content where the intermediary compliance with FCU determination rather than user intent become crucial. Now there is one more thing which is important, and this is fake or false or misleading. Now to a layman it will make no sense what we are talking about. Now what the judge has done is they have gone, this is basically the same thing which you go to this particular clause, you will find here the word fake, false, or misleading being used, which is kind of getting adjudicated and interpreted in this particular provision of the section of the judgment. Now, what does it basically means? Now, this fake, false, and misleading words are not interchangeable. Means they are not treated as part of the same theme. They are treated separately because of the use of or here. And this is very, very technical, by the way. The or is making these things separate. Now, to a common man, it makes no sense. But what the judge is saying that the use of or between the word makes the interpretation very wide, expansive, giving excessive power to fact-checking unit. Means you can either brand a category of information under fake, or under false, or under misleading. Means you have got full power to do whatever you want. So that makes it very, very expansive, and that is why this ambiguity gives the FCC unit discretionary power without clear framework or potentially leading to arbitrary enforcement, right? And then comes the ultra virus challenge to impinge rule under Act of 2000. Now, what this basically means, and we have less time, so I'll just go a little fast. It basically means that under the IT Act, if you introduced a rule, then that rule should be laid before the parliament. And there are other provisions also, but I find this provision very, very important, which is 83(3) of the IT Act. And you haven't done that. You came out with the rule and you did not put the rule, and you came out with the fact-checking unit without going through it. So if you go to the tiebreaker judge perspective, it says that I concur with Patel J. Amendment of rule is ultra virus to the Act of 2000 because the amendment does not properly present before with the parliament as required by section 87(3) of the IT Act, and the rule does not align with the specific provision of certain other acts related to blocking, access, and guidelines of intermediary respectively. I don't want to get into detail, otherwise the video will become too long. Then we have the point about chilling effect of the impunge rule. Now, what is chilling effect? The chilling effect, the theme is impending fear of pick and choose by government censorship or digital company. You pick and choose whatever you want to pick and choose, right? There is no clear guideline. There is no definition of what is fake, misleading. Nothing is there. You determine what is fake, misleading. So that is what the tiebreaker judge is also saying, because he says that in accordance with this ruling, and considered vague and expansive nature of the impunge rule, I align with Patel J's view that the rule potentially suppress the freedom of free speech by placing undue constraint on intermediaries. And then there is a point about proportionality, and you can read through in this article, and the theme is that the rule lacks adequate safeguard to prevent abuse and does not demonstrate that it employs the least restrictive means necessary to combat fake, false, and misleading information. So there has to be, every law has to be proportional in nature. So I just will read what the tiebreaker judge is saying. I uphold the challenge of the impunge rule fails the proportionality test, especially it seeks to limit the fundamental right of Article 19(1)(a), which we spoke about, 19(1)(g), which is basically to do any profession. The rule lacks adequate safeguard to prevent abuse and does not demonstrate that it employs the least restrictive means necessary to combat fake, false, misleading information. Consequently, the rule infringes the fundamental right, is neither justified or proportional, and aligns with Patel Ji's observation. On this ground of proportionality, impingement cannot be sustained. And then I conclude, right? So my conclusion is very simple. It's not, everything has been basically discussed in this video. So the detailed analysis of the tiebreaker judge, supported by the precedents and the rigorous legal scrutiny, has ensured that the digital space remains free of ideas rather than regulated in an echo chamber subject to any whimsical government. Because see, government has its own interest, right? It wants to ensure that whatever shortcoming is there in its governance should not get leaked out. It will go all out to prevent such information, because otherwise its chance to win elections in the next phase is going to become diluted. So they will try to prevent such information. So that is not proper for democracy and free speech. And the judgment not only navigates through the complex legal constitutional queries, it also set a robust benchmark for future legislation and policy making. So I think this is very, very landmark judgment. Everybody should be happy about it, that we have a judge, the judgment which has gone into every aspect of constitution and analyzed it in such a way that it is watertight. It has been, if you look at this judgment, it is not very long. It is a 100-page judgment, and it has gone into each and every aspect of law and has analyzed it in a very thorough manner. So that's why I spend the time to do this video as well as this article. The whole day has been spent by reading all this document, but I thought it is important to understand this from my own perspective, and in the process I did this video and this article so that it remains as a reference for me, for my future reference, as well as the others can also benefit from this. Thank you very much for your time, for listening to the end. I will come back to you with a new video next time.